That's a really good question, and this comes up pretty frequently. So the misunderstanding or the misconception about this question is that if an individual or the victim wants to drop the charges, I'm scot-free, right? But that is not always correct. In fact, the state or the prosecutors are actually the people who make the decision as to whether or not you are charged with a crime. So the victim then, their opinion matters, but it's not the entire reason why the state would continue to charge you with a crime. So victim recantation, or when a victim changes their mind, can be significant in a number of ways. It can help you at a jury trial, if that's the direction that we decide to go. It can also help you if you decided that you wanted to take a plea for it. However, it does not necessarily mean that the state is going to drop their charges. They can still say that we can still prove the charges even without the victim's statement. And if that's the case, then you're still facing your criminal charges and you still have to come up with a defense, or your attorney would help to negotiate a lesser offense for you and penalty. Self-defense is a very valid defense in many situations. Whether you acted in self-defense or not can be an issue of negotiation for your attorney and the prosecutor. That can help to either get your case dismissed, get it reduced, or help you as a defense when you go to a jury trial. So it's not a guarantee that your case would be dismissed simply because you acted in self-defense. However, depending on the situation, it can grant you a dismissal, it can lower your penalties, and you could win at a jury trial. That's never a guarantee, but if you have a self-defense claim, it is something that your attorney has a duty to explore with you. So in a case where the identity is at issue, meaning how does the state know that you were the individual that is being accused? Well, for one, oftentimes that statement will come from the victim, right? If the victim is claiming that that was you, then the next question would be, how do we substantiate what this victim is saying? If it's a he said, she said, then sometimes what it comes down to is a matter of credibility at a jury trial. And your attorney can walk you through that. However, if you decide not to go to a jury trial, and let's say you decide to take a plea, then your attorney can walk you through how do we negotiate this so that your attorney can present the facts to the prosecutor to say it is difficult to prove the identity of this this person, this alleged person who committed this crime, and for these reasons. And if your attorney can bring up those issues, those are what we call mitigating issues. Those are points then that your attorney can use to negotiate with the state in order to lower your charges, perhaps amend them, or get your case dismissed.